This is Marcy here from NINA, and I'm really excited to have Partridge from Benchmark Title and Keith Madden from Stewart today. Hi, how are you guys?
Great, how are you?
Thank you. Well, thank you so much for asking. So you've probably all heard out there a little bit about this transfer on death deed, this new law that's been enacted in New York State. There's a little bit of controversy or misinformation going on around there. So we thought this would be a good opportunity to get from the experts a little bit about this. So without any sort of further ado, I'm going to turn this right over to Jean and Keith.
Good afternoon, everyone. And boy, what an honor to be the speaker on National Notary Day to a group of notaries. We had no idea. So thank you for having us. Keith and I have done this presentation multiple times. It's really geared towards title people and attorneys who will be executing these deeds, but we really do what I'd like to say is a thorough overview of the whole statute section by section. Marcy will be monitoring the chat box. If you have questions, she will pipe in and ask us. We're okay with getting questions either during or after the presentation, so no question is dumb. We've been asked all kinds of things, and you know, there are occasions when we may not know the answer just because it's not yet been determined by a court or it's a gray area or whatever. Okay, so now we're going to start with what you see on your screen is, Keith?
So what you see on your screen now is essentially a quick little overview of the Heirs Property Protection and Deed Theft Prevention Act of 2024. We're not going to recite that whole name every time we reference the statute, otherwise we'll spend all of our time just reciting the statute name. But what you see here is essentially an overview of the various sections of Section 424 of the Real Property Law. A quick note on Section 424. A couple of decades ago, it used to pertain to land title registration, like the Torrens registration system. That whole system was repealed back in, I think it was either January of 2000 or January of 2001. Don't quote me on the date. But if you do a search on Google for Section 424 of the Real Property Law, just make sure that you're looking at the transfer on death deed statutes and the heirs property protection and deed theft, well, the statute, and not actually the title registration, or else anything that we're saying now is going to make sense later on.
So it's our hope to get through all of these sections today, but just as with any seminar, there is never a substitute for actually reading the statute. Some of it is difficult to understand, even for legal scholars, because that's how our legislators write legislation very often, but most of it is plain language, and everyone should have no problem in reading it, and I strongly suggest that you do so. So as many of you are aware, as part of the 2024 New York State Budget Bill, the Heirs Property Protection and Deed Theft Prevention Act of 2024 was passed. The introduction of this section, new section of Real Property Law 424 in the budget bill brings about changes to real property transfers with the inclusion of transfer on death deeds in New York. Going forward, Keith and I are going to refer to these as TODD, T-O-D-D. It's just a lot easier and simpler to say that than transfer on death deeds every time we use that word. And there is a prize at the end of the presentation. If somebody gets the correct number of times, we do use the term TODD throughout this presentation. Anyway, TODDs are utilized in a majority of states. New York was kind of at the tail end of states that enacted this legislation. The main purpose of it was to avoid the necessity of probate. The idea was that for people who can't afford to go through probate, that they would use this transfer on death deed. So some key aspects in this legislation, the transfer, what does the transfer on death deed do? it basically is a conveyance of your property that only becomes effective upon the death of the owner. Until then, it has no effect, and it's really not a conveyance until the moment of death. Unlike a regular bargain and sale deed, the statute requires the TOD be signed by two witnesses who were present at the time and who witnessed the signing of the TOD. Important to note that the statute is silent as to the requirement to have witnesses on the revocation of a TOD, which we'll talk about later. However, the form, which is set forth in the statute itself, does have signatory lines for two witnesses on a revocation as well. Note that the statute is also silent as to whether the notary can also be a witness. Since the statute is silent on that matter as title insurers, we do not think that a notary should be a witness. And it may create a cloud on title later on. So we would highly recommend that if you are providing notarial services, that you are not a witness on the TOD deed.
Just bear in mind that I'm at Stewart Title Insurance Company. I can't speak for other title insurance underwriters, so you may get some disagreement as to this, but I think that discretion is the better part of valor there, quite frankly.
And it is, I write for, I'm a title agent. I write for all 8 underwriters, and that is the consensus, not to have the notary. Is it void ab initio? Maybe, maybe not, but we don't want to litigate it. And as insurers, that therein is the issue. A TOD is subject to the property covered under a TOD remains subject to any liens or mortgages existing at the time of the owner's death. The interest of the designated beneficiary is contingent upon surviving the owner. So thus, if the beneficiary does not survive the owner, the beneficiary named in the TOD gets nothing. The owner retains the right to transfer the property to someone other than the designated beneficiary during their lifetime. So the way a TOD would work, and the form is in the statute, we'll get to it later, is Gene Partridge would put on a TOD to Keith Madden. So I love Keith, and I want Keith to get the property upon my death. It's my only asset, so we don't have to go to probate. Everything is fine in the event I predecease Keith. If I predecease Keith, then at the moment of my death, Keith becomes the owner pursuant to that TOD. However, if Keith predeceases me, the TOD is of no force and effect. Keith's heirs don't get it. Keith gets nothing, and the property will go back into my estate. If 6 months later, after I execute the TOD, have it acknowledged and record, because that's a requirement, I decide that, you know what, Keith is a real schmuck, and I don't want Keith getting my property at my death. I can simply convey to someone else, either via a TOD, a new TOD, or a bargain and sale deed, and that will void Keith's TOD that was first recorded. There are, we'll get into the more intricacies of revocation, but that is absolutely a way to revoke by subsequently conveying via a bargain and sale deed or another TOD to someone else. And again, we're going to go into more detail later on. Interestingly, the statute provides that the TOD is effective without the need of notice, delivery, acceptance, or consideration by the designated beneficiary during the owner's lifetime. So that means that I could record a TOD to Keith, and Keith may never know it. He may not know it till I die years later. Then my mortgage is defaulted on, and the mortgage starts a foreclosure proceeding because they do a search and see that Keith is is now the owner. Most municipalities also do not view the TOD as a conveyance, and therefore, with the exception of Erie and Niagara that I know of, Nobody's requiring a TP 584 or 50, RP 5217 to record a TOD. Certainly no one in the downstate jurisdictions. Those are the only two we know of so far.
Right.
Correct?
And I had thought that it was Nassau County that was requiring, but it's actually Monroe County that's requiring a completion of TOD
Right,
to be filed.
upon the death.
Yeah, so Monroe County, like Rochester, they're requiring a completion of TOD to be filed after the death of the transferor.
And Nassau County does have some additional requirements, which we'll talk about later. The statute also requires that the signatures be acknowledged before a notary and that the TOD be recorded prior to the owner's death. So that's just, an outline of what the statute covers. And now we're going to go section by section, and I pass you over to Keith.
Okay, so Section 424, definitions. I'm only going to hit the highlight reel of this because, well, definitions are important, but I don't want to waste all our time going through them. Joint owner, well, a beneficiary is essentially the person that's named to receive the property upon the transferor's death. A joint owner means an individual who owns property concurrently with one or more other individuals with a right of survivorship. So if I'm a tenant in common with Gene, we're not considered to be joint owners under this statute. In order to be a joint owner, you need to have a right of survivorship. That could be a joint tenant with the right of survivorship, or it could be a tenant by the entirety. A person means a natural person, an association, a board, etc., a corporation, etc., etc. What it does not include is a limited liability company or a trust. So if you are drafting a TOD, bear in mind that neither a trust nor an LLC should be named as a beneficiary in that document, or else there's a strong argument that it's going to be invalid. And I know that in other states with transfer on death deed legislation, it's been held that unless the entity is specifically named as an eligible beneficiary, i.e. a person, that it is void in those other jurisdictions. So just bear that in mind. Property, I don't think that we're creating any new and exciting law there. Transfer on death deed, well, that's what this is. The transferor means an individual who makes the transfer on death deed. I'm just going to draw a distinction between transferor and a grantor. A grantor is in a deed, and they're conveying a present interest in the property. The transferor here under this statute is the fee owner of the property. They're signing this, and again, that TOD does not take effect up until their death.
As Keith just pointed out, it's very important to note in this statute, the terms grantee or grantor are not used whatsoever. The transferor is the owner of the property, what would be a grantor in a bargain and sale deed situation. And the beneficiary or designated beneficiary is what would be deemed a grantee in a standard bargain and sale deed. But it's important to note that those terms are never used in the statute.
Right. So let's keep on plugging along through some of these definitions, or through some of the sections here. I'm sorry. Non-exclusivity. A TOD is not the only means that a person has at their disposal to dispose of real property. Sorry. You don't have to use a TOD if you don't want to. Section 3, TOD authorized. Essentially, hey, this is the section of the law that says that TODs are permissible in New York State. Section 4, the TOD is revocable up until the moment of the transferor's death. Number 5, the TOD is non-testamentary. You don't need to commence a probate proceeding in order for the TOD to take effect. And as a matter of fact, one of the key reasons that the TOD was such an important item to get pushed through was because the surrogates courts in New York State have been pretty far behind as far as issuing letters testamentary or even preliminary letters. I mean, we've heard tell of some counties being at least a year behind as far as that's concerned. So this was a means of avoiding the delay of having to go through surrogates court. Section 6 here, capacity of the transferor. The transferor in a TOD needs to have the same capacity that is required when they're executing a deed. They need to have the same capacity as required when they are executing a will. Okay, essentially, they need to be of sound mind. They need to know what they're doing. They need to know that they're disposing of the real property. They need to know who their beneficiaries are. They need to be of sound mind.
You'll note as we go through the statute that there are many similarities in the requirements of what's required in a deed, but there are also many similarities of what's required in executing a will. It's kind of a melding of both. So section 7 of the statute sets forth the requirements for a transfer on death deed. A TODD must contain it starts with the TODD must contain the same essential elements and formalities of a deed, meaning it must be recorded and acknowledged. It must contain language that the transfer only occurs upon the death of the owner or the transferor. Must be signed by 2 witnesses. Here, that's a will formality, not necessarily a deed formality. Must be acknowledged, and very important, must be recorded before the transferor's death. So we're going to give you an example of this. Keith. A TODD from Jean to Keith is dated August 1, 2024. Acknowledged August 1, 2024, and recorded on the 6th of August. Unfortunately, I'm hit by a bus and I die on August 4th, 2024. Is that TODD valid?
Unfortunately not. Again, the interest conveyed via a TODD is contingent upon the transferor surviving up until it gets recorded, and we'll get into the beneficiary surviving in a couple of seconds.
Right. So, because I died before that TODD was recorded, it's invalid, of no force and effect. So same facts as above. Jean conveys to Keith, dated and acknowledged on August 1, recorded on August 6. However, in this case, Keith is hit by a bus before the TODD is recorded. Keith remembers the beneficiary. Keith, is this TODD valid?
Unfortunately not, because under that circumstance, I've passed away before the TODD has been recorded. And even if it had been recorded at that point, since I died before you, the interest being conveyed lapses at that point, and the property goes back to, well, it doesn't even go back to Jean. It remains with Jean, and the TODD is of no further force or effect because I have predeceased. And by the way, call Greyhound or want you starting an action against Greyhound.
Right. So the key takeaway here, and what's very important to remember, is both the transferor and the designated beneficiary must be alive at the time of recording of the TODD in order for it to be effective. Oops, I went the wrong way. Hold on.
Jean and Keith, I have a question. They would like to know, do you have to file the executed TODD in any municipal office?
No.
Just the county clerk's office.
And therein lies a problem that we pointed out before, is that typically when you record a bargain and sale deed, you're filling out the TP 584 and the RP 5217, a copy of which gets sent to the local municipality and the state. And this is how the local municipality learns of the conveyance and will change the records, for tax bills. With a TODD, there is no notice to the municipality. And again, sometimes the only way they find out is, let's say the owner passes away, taxes go delinquent because nobody knows who owns the property. Keith doesn't know there was a TODD recorded. And so now the town or the municipality will commence a foreclosure search. So they'll go in the record, they'll search, and they'll say, oh, look at this. Keith is now the owner of the property pursuant to this TODD because Jean has died and Keith is alive. And then they will start sending Keith the delinquent tax bills. Same thing if it's a mortgage foreclosure scenario. And that may be how Keith will learn that he is now the owner of this property.
And maybe they start sending me those notices, because without that TP 584, the RP 5217, they may not have an address to send those tax notices to me. So I may end up getting served via publication. I think that's
Well, yes and no, because the TOD deed requires you put your
the
address,
okay,
but
yeah,
if
that's
you,
right. Yep.
if you move. So, however, in the real world, we think this is very unlikely to occur because typically, the owner is going to tell the designated beneficiaries. In most of the instances I've seen them use so far, it's a parent to a child. So they would most likely, the designated beneficiary would be aware that they were the designated beneficiary under a TOD. They're going to be aware that the transferor has deceased and they now own the property.
One of the things we went through before actually was that the notary needed to be, or we would prefer to see the notary as a separate person from the witness. The other reason I think that from a practice perspective, and I don't know how many of you out there are attorneys on it that do any sort of trusts or estates, but when somebody signs a will, generally speaking, you have the two witnesses, sign the will.
Right.
And as part of the will signing ceremony, the witnesses will often sign something called a self-proving affidavit. The reason for that is that when an executor goes to probate the will, the surrogate's court can call in those witnesses to testify to authenticate the will so that it can be admitted to probate. What the self-proving affidavits do during a will signing ceremony, it's essentially a sworn statement by the witnesses that is admissible as evidence, and that obviates the need to call in those witnesses later on. And the notary, the will signing ceremony, would notarize those documents. If the notary is acting as a witness, the notary is not going to be able to notarize their own signature. So, and that's often when you're doing a will, you see the notaries separate from the two witnesses. I would do the same thing here with the TOD, just because what happens if somebody challenges the TOD later on and you can't find the witnesses? Maybe the witness passed away, maybe the witness has absconded, or just disappeared.
Yeah, I agree 100%.
I think you get the self-proving affidavit, you avoid the issue that way.
Mm-hmm.
Anyway, I'm sorry.
No problem. So moving on to the next section of the statute, section 8. Section 8 basically says, or does just say, notice, delivery, acceptance, and consideration are not required in a TOD. So Keith could record a TOD to me, and I may not even know I've been given this property until his death, as we've said before. So again, this goes, the fact that notice, delivery, acceptance is not required and it's not really deemed a conveyance is why the TP and RP forms are not required in most counties. As a caveat, though, we want to tell you, based on real life experiences so far, as we earlier mentioned, Niagara County requires the TP 584 and RP 5217, as does Erie County. Nassau County requires a statement on the deed that witnesses, regarding witnesses, which we'll show you when we get to the form of the deed. They want an extra sentence in the deed from the statutory form, basically saying the witnesses appeared before the owner. And although Nassau County does not require the TP or the 52, they still require you to pay their beloved tax map verification fee to record a deed. It's just a money grab.
Unbelievable.
Yep. Nassau County is also, in addition to Rochester that Keith mentioned before, requiring a form to be filled out, and they're calling it a completion of TOD form. Yeah. And they are asking that the beneficiary to sign and acknowledge and file that document upon the beneficiary's instance of ownership. So basically an acceptance,
right.
Of the conveyance.
What I might do if I found myself as being a beneficiary in a jurisdiction that wasn't requiring a form like that, I might do a confirmatory deed from myself to myself, just to change over the tax records and make sure that everybody knew that I was the actual fee owner of the property at that point. I think that might be maybe a practice tip that might streamline insurability as to transactions later on. And we'll get into a little bit of that.
Yeah, I think we're gonna see more and more municipalities wanting some type of,
And I would just bear in mind that the counties, they're still very much in flux about what they are requiring here. I was actually on a meeting this morning for New York State Land Title, and the County Clerks Association is still a little bit all over the place with.
they are, because it's not a statewide rule or a
Right.
mandate. Each clerk can do what they want. So, unfortunately, recording requirements are somewhat different in different jurisdictions. So now the long-awaited revocability methods, Keith is going to talk to you about a little bit.
Sure. So the statute provides 3 ways to revoke a recorded TOD. Number 1 is the transferor can complete and acknowledge a new TOD that disposes of the same property which expressly or by inconsistency revokes the TOD. So if Jean signs a TOD in favor of Keith, designating Keith as the designated beneficiary, and then several months later she says, I'm not such a big fan of Keith anymore, I'm going to designate a new beneficiary, she can sign a new TOD, and that would act as a means of revocation. Number 2, complete and acknowledge a revocation form. Okay, there is a form of revocation given in section 424 of the real property law, and a transferor can fill out that form. A quick note on that: the statute is actually silent as to whether the revocation form needs to be witnessed, but the form itself contains a signature block for 2 witnesses. When I was in private practice, my mantra every day was, please God, let me keep my cases out of the law school textbooks and let my client not be the test case. Is the revocation required to be witnessed? I'd say it's ambiguous because the statute is silent, but the form has the signature blocks for it. I would avoid the issue by having the revocation witnessed by 2 independent witnesses.
Keith, does the revocation have to be recorded?
It does. It absolutely does. Yep. It needs to be, same thing as with the TOD. It needs to be recorded before anybody dies. Number C, said what I said. The 3rd means of revocation is that the transferor can transfer the property to somebody else during the transferor's lifetime by recording a deed that expressly revokes the TOD. Now, we have a funny little asterisk around this one. Does the deed need to expressly revoke the TOD in order to revoke the TOD? Maybe is the best answer we can give for that. The statute here seems to say yes. However, if the TOD is not conveying a present interest in the real property and a deed does the deed need to actually and expressly revoke it? Arguably not. But again, keeping with my mantra of keep my cases out of the law school textbooks and don't let my clients be those test cases. If you know that there's a TOD on record and your client is selling the property or transferring title, I would definitely put down a quick sentence in whatever deed is being executed that it's revoking all TODs that may have been executed previously.
Agreed. Let me ask another question.
Sure.
So once again, I executed TOD to Keith, dated July 24th, and then I execute a revocation on August 1st because I get real mad at you.
Mm-hmm.
The revocation is dated, acknowledged on August 1, recorded on August 6th. Unfortunately, that Greyhound bus hits me again, and I pass away on August 4th. Is the revocation valid?
No, it's not, because it hasn't been recorded prior to the death of the transferor. However, as a title insurance company, we're going to be very interested in whether or not there might be competing interests. So if the TOD was revoked, but the revocation isn't effective, we're going to look to see who might inherit the property, who the designated beneficiary is. We're essentially going to be looking for discrepancies, and we look to resolve those discrepancies. And we'll get more into insurability in a little while, but in case we run out of time, you should just be aware that well, we look for those discrepancies, and just because something is legally valid doesn't mean full speed ahead. It means that we may still have other questions to have answered.
So what happens when a TOD is made by more than one transferor?
Okay.
So Jean and Mary own a piece of property, and we do a TOD to Keith. How does that work?
So it's going to depend on whether or not Jean and Mary are joint tenants with right of survivorship, or married, or they're tenants in common. If Jean and Mary are joint tenants with right of survivorship, or tenants by the entirety, then both Jean and Mary will need to execute that TOD in order for it to be fully effective.
And the revocation.
And the revocation, right,
Right.
and the revocation, in order for that to be fully effective, right. If they are tenants in common, then each of Jean or Mary's interest is separately descendable via a TOD, if that's the right phrasing to be using. They could each dispose of their own interests via a separate TOD if they're tenants in common.
So by example, if Jean and Mary own a piece of property as tenants in common, and Keith is a designated beneficiary, upon Jean's death, Keith will have a 50% interest.
Right.
He will not be a fully vested owner until the death of both parties. However, by the same example, if Jean and Mary are joint tenants, I cannot individually revoke the TOD. Mary would have to join in with me in order to revoke any interest that Keith may have. Okay.
Right. Another
Jean and
quick.
Keith, I'm so
Go
sorry.
ahead.
Yeah.
Yep. Go ahead.
I have two questions. So the first one is, how can a TP and RP be signed for a confirmatory form when the seller is dead?
So with the confirmatory deed, there's not actually the seller. So again, in keeping with the Keith gets hit by a greyhound theme, Keith signs a TOD in favor of Jean as the designated beneficiary. Keith has his greyhound accident. Now Jean owns the property. Jean owns the property by operation of law at that point, because the TOD was recorded prior to my death, prior to Jean passing, and Jean has survived. So the TOD is effective, and Jean automatically becomes the owner of the property upon my death. The confirmatory deed, essentially Jean is signing as both grantor and grantee, or she's signing the TP 584 and the RP 5217 as grantor and grantee, because it's not, the confirmatory deed isn't actually changing title or conveying title, it's confirming title in that same person. So that's how Jean was able to execute those documents in both capacities.
And the second question, did you have more to that? I'm sorry.
Did you have another question as well?
I do. So if a TOD deed contains two primary beneficiaries, can a TOD under the alternate beneficiary section contain language where interest is transferred to the issue of a predeceased primary beneficiary? For example, if one of the primary beneficiaries predeceases owners herein, that beneficiary's share shall be devised to his or her surviving issues in equal shares.
Excellent question, but there's really, unfortunately, a kind of quick and dirty answer to that, in that the New York statute does not allow for alternate beneficiaries. There is no language anywhere in this statute that allows for alternate beneficiaries whatsoever. That being said, the form that our legislators put in the statute does have a line for an alternate beneficiary. We suspect that they just took the model form from the model TOD statute and never crossed out alternate beneficiary. So we are taking the position, and all underwriters, from an insurance perspective, that alternate beneficiaries are not permitted. So the answer is you can only have designated beneficiaries. And, other than that, if both designated beneficiaries predecease the owner, the way to dispose of the property is either a new TODD, a new inter vivus bargain and sale deed, or via probate.
Right.
So, good question, but that is our position on that.
And just to get back into estate planning, I mean, the TODD isn't the only tool that's available. I mean, if I'm worried about various beneficiaries predeceasing me, if I'm, I have fairly young kids and I'm maybe oversharing a little bit much of myself, but I have fairly young kids. I'm anticipating that I'm going to be around for a long, long time. If I'm looking to dispose of property so that it doesn't go into my estate during or following my bus accident, I also have the option of executing a trust and transferring the property into a trust. So just because this is the newest tool in the toolbox doesn't necessarily mean that it is the best tool in the toolbox. It doesn't mean that it's going to fit all situations. So let's not forget that there are other estate planning devices that are available for people to use.
Right. So, Keith, what happens when a will divides property to Jean, but a TODD is recorded with Keith as the designated beneficiary? What do you do when you have those conflicts?
So the TODD will not be revoked. A will cannot revoke a TODD, okay? However, when it comes to insurability, if I see a TODD in favor of person A and I see a will in favor of person B, I'm going to, legally speaking, person A, the designated beneficiary, has the property. But from a practical / insurability standpoint, I'm going to be very concerned about whether person B might think that they have the property, who's living at the property, who's paying the mortgage, if any, who's paying the real estate taxes, the homeowner's insurance premiums. How likely is it that person B asserts a challenge to somebody else's claim of title? I'm going to be very interested in answering those questions because as a title insurance company, in the event of a challenge, once that challenge comes in, once I have a claim under that policy and I end up having to defend my insured's title, I'm already upside down on the premium. I have already lost from a business perspective at that point. So I want to resolve discrepancies to the best of my ability. Regardless of who I think might win, I want to resolve those discrepancies to the best of my ability prior to the issuance of a policy.
And remember, this is a new statute, and some of the questions we're posing will eventually be litigated in court, and then we'll have the answer. But as of now, there are many unanswered questions as to what will happen. And as title insurers, our role is risk avoidance. So we will attempt to avoid any possible risk so we don't get involved in the legislation.
Again, let the client not be the test case. That's the overarching goal.
Yep. Okay, go ahead.
Okay, so section 10 of RPL 424, the effect of the transfer on death deed during the transferor's life. The quick answer, there isn't. A TODD shall not affect the right of the transferor or any other owner, affect the interest or right of the transferee, affect the interest or right of a creditor, affect the eligibility of the parties for any form of public assistance, create a legal record. You have the rest of the statute there. So if I sign a TODD and I decide that I'm going to run over my next door neighbor and then I back over him just to be safe, and now I have $1 million judgment against me. If I have previously signed a TODD, or if after that judgment is docketed, I sign a TODD, that judgment creditor is still going to be able to pursue the real property. They still have a lien on the real property by virtue of that judgment, okay? If I am receiving a senior citizen's exemption for real property taxes, or if I'm receiving a veteran's exemption, chances are that TODD is not going to affect my eligibility for that exemption, okay? If I have named a designated beneficiary in my TODD and that designated beneficiary is maybe receiving Section 8 assistance as far as rental payments, that TODD is not going to affect the designated beneficiary's eligibility to continue to receive the Section 8 payments, okay? If I'm receiving Medicaid assistance, and this I think is a much more common question, If I am the transferor in a TOD and I'm receiving Medicaid assistance, signing a TOD is not going to affect my eligibility. So I think I would just bear that in mind. If I'm currently not receiving Medicaid assistance and I need to dispose of my property in order to qualify to receive Medicaid assistance, TOD isn't going to do the trick there. That's not going to dilute the value of my taxable estate.
Okay, we have like 15 minutes.
Oh, I'm
so we're
sorry.
gonna speed a little bit, but I just have two questions to pose to you. I once again recorded TOD in favor of naming Keith as a designated beneficiary. 6 months later, I decide, you know what? I need to take out a home equity loan. I need to mortgage the property. I have to put my kids through college. Can I do that? A, and B, do I need to notify you?
Yes and no. Yes, you can absolutely mortgage your property, notwithstanding the existence of a valid TOD. And number two, no, you don't need the designated beneficiary's signature or consent on that, because that TOD does not convey a present, a salable, a mortgageable, or I would say an insurable interest in the property.
Okay, now, what same scenario? I record a TOD in favor of Mr. Madden. 6 months later, and you know, he's my buddy, he knows about it. 6 months later, Keith decides, hey, I really need a home equity loan. I have to put my kids through college. I'm gonna put a mortgage on Jean's house. Is that permissible?
No, because again, Keith does not have a present, salable, mortgageable, or insurable interest in the property.
Keith, you're up again.
No, all right. Okay.
So section 10 dealt with the effects of what a TOD deed shall not do. Section 11 deals with this is what a TOD deed does do.
So this is the effect of the transfer on death deed at the transferor's death. Okay, this is the magic moment. This is where it all happens as far as the TOD is concerned. Okay, upon the transferor's death, the TOD conveys the interest in the property to the designated beneficiary. Okay, the interest of that designated beneficiary is contingent upon the beneficiary surviving the transferor, or otherwise, as we said before, the interest lapses. All right. Concurrent interest shall be transferred to the beneficiaries in equal shares with no right of survivorship. Okay, so I can't sign a TOD deed and say, okay, my designated beneficiaries are Jean and Vanessa as joint tenants with right of survivorship. Okay, I can only create a tenancy in common via the TOD deed. Now, that being said, if I have signed a TOD in favor of Jean and Vanessa, and then Jean ends up passing away before Vanessa does, okay, that means that Jean's 50% interest lapses, but because Vanessa is also named as a primary beneficiary, Jean's interest would go to Vanessa in a proportionate share. So if I've named Jean and Vanessa as the two beneficiaries in my TOD, then Vanessa would get the share that otherwise would have gone to Jean. If I name Huey, Dewey, and Louie as my beneficiaries, and then Huey passes away before I do, that means that Huey's 33 1/3% interest would go proportionately to Dewey and Louie. They would each end up with a 50% interest. And that's, I guess, a nuanced little point. So I don't create.
But yet people are very confused by this section.
Yeah.
So summarizing what Keith just said, all designated beneficiaries must have concurrent interests, and they have to have like interests. So I cannot do a TOD deed giving Keith 60% and Joe 40%.
Right.
That is just not permissible under the statute. And we get a lot of questions on this. So, I just wanted to reiterate that point.
Right. A transfer on death deed transfers that property without any covenant or warranty of title, even if it's recited in, even if that TOD contains a contrary provision. So I would just want to point out that you're not going to see your Section 13 lien law language in that deed. You're not going to see The covenant
Appurtenances.
against grantors act, what's that, I'm sorry?
Or any appurtenances.
Or any appurtenances, right. You're not gonna see those covenants there. Okay, I'm sorry, I'm jumping ahead a little bit.
Oh, sorry, go ahead.
Okay, no, that
Priscilla.
was me. I jumped
Okay.
ahead trying to keep up on time.
So I'm gonna go back to that Huey, Dewey, and
Oh,
Louie
sure.
example
Yeah.
because it was quick, but we get a lot of questions on that. Jean and Keith, we're married. We're execute a TODD deed to my son, David, to our son, David. I pass away, but Keith does not. Who owns the property at the moment of my death?
At that point, Keith owns the property because Keith and Jean owned as tenants by the entirety, and then Todd isn't going to affect that right of survivorship.
Mm-hmm. And same scenario, Jean and Keith are married. However, we execute a deed to our 3 children, Huey, Dewey, and Louie. Per the statute, remember, each must have a 33 1/3 interest. So what happens when Huey dies?
Well, if Huey
Who
dies,
are the owners?
right. So if Huey dies before you and I do, and then we pass away, Dewey and Louie would each end up with a 50% interest in the property because Huey's 33 1/3% interest that would have otherwise been conveyed via the TODD is essentially goes to the surviving designated beneficiaries. But no, that happens. That's assuming that Huey passes away before we do. We can't make it so that Huey's interest
before we both do,
right,
not one or the other.
Correct.
So we hope we explain that correctly and everyone gets it. If not, you could post questions. Marcy will ask us, and if we don't get to them during the presentation, we'll respond after that. So moving on to the next section of the statute, it's section 12. Basically what we spoke about earlier, the principles of fraud, undue influence, etc., apply to a TODD, just as they would when you're executing a deed or a will. Divorce, annulment, dissolution of a marriage shall have the same effect on a TODD as outlined in 5.14 of the EPTL. What does that mean? EPTL 5-1.4C basically says divorce, judicial separation, or annulment severs your tenancy by the entirety and you become a tenant in common. So in our prior examples, if Keith and I are married, we execute a TODD to Joe and we get a divorce. We have a legal divorce. Upon my death, Joe will now have 50% ownership. He will not necessarily have to wait till we both die, right, because our tenancy by the entirety is severed by the divorce. Okay. Just as you can devise or bequest under a will, you may renounce under a TODD. How do you do it? The same way you do under a will, under EPTL 2-1.11, which is a writing that must be acknowledged within 9 months of death. Okay. This section here is really the most troublesome section to me. Read what this says above. The estate may enforce the liability against the property transferred at the transferor's death by a transfer on death deed. What does that mean? Is that akin to an inchoate interest on the property from the date of death? If yes, you should ask yourself, how can title insurers ever insure a conveyance made under a TODD deed without 18 months passing? The answer is, check with your underwriter. If you're an insurer, some underwriters would have indicated to me they would be willing to insure prior to the 18-month period. We need to review the facts and circumstances, right, and the totality of the situation. If there's only one heir, that's going to be a lot different than if there's multiple heirs. If we are provided affidavits that all expenses and statutory allowances were paid, there are ways around this section. And once again, it hasn't been litigated, so we don't really know exactly what it means. So, with real property, if a creditor has not filed a lien or a judgment against the transferor, the lien cannot be a lien on the real property. However, the bigger issue is that in this section as written, it may theoretically allow the creditor to divest the designated beneficiary of title. The courts are going to have to decide this. We don't think that's the way it'll go due to the protections under the Recording Act and other protections, but as written, that is feasible.
The designated beneficiary, I think, is much more at risk for a creditor come forward to try to divest title, because remember that consideration isn't something that's required by the designated beneficiary. I think the more problematic question we're going to get is, what happens when the designated beneficiary sells the property to an unrelated third party as part of an arm's length transaction, and then the creditor comes forward to try to enforce. I think that that's going to be the real issue, because again, from an insurability standpoint, we're probably not going to be insuring title in the designated beneficiary too frequently. We're probably going to get asked to see, and again, this is relatively
But out
new.
of the, we may get asked to insure
out of the designated beneficiary. Right. Now, I mean, speaking as somebody who used to, in a prior life, litigate cases with more frequency than I care to recall, I like the bona fide purchaser, bona fide arm's length purchaser's defenses there, because RPL 291 is the recording statute, and they're a BFP. There's also, now I've also done a lot of research on the notice of claim versus the estate that gets filed in the surrogates court proceedings, and the notice of claim against the estate in the surrogates court, I have not, and I welcome any contrary authority or any contrary differing opinions on this, but I have not found any authority, a case, a statute, a regulation, etc., that elevates a notice of claim against the state filed in the surrogates court proceeding to the level of a lien against the real property. I haven't seen anything making it a judgment, mechanics lien, a notice of pendency. As far as I can tell, what the notice of claim against the estate does in the surrogates court is it potentially creates personal liability on the part of the fiduciary if the fiduciary ends up disposing of the real property or any property without paying the claim of that creditor that's been filed. Okay.
We have 2 minutes. So,
okay. Go ahead.
So that's really mostly the, every section in the statute with the exception of the forms. Section 15, the statute, as we said earlier, provides a form of transfer on death deed. We highly recommend using this verbatim because you don't want to litigate if you put something in or took something out. The form is on our website if you want to take a look at it. And I wanted to point out just 2 things. You'll see here, circled in red, the form does have a space for an alternate beneficiary. But as earlier mentioned, the statute doesn't provide for same. You'll also see in the red there, I put on this day before me, witness 1, witness 2. That is required language for Nassau County. So we just wanted to highlight that for you. The next page in the statute, this is actually part of the statute. There's Q&As about how to use the TODD, really directed at the layperson who may want to do a TODD without the assistance of an attorney. The next form in the statute is a form of revocation. Again, as you can see here, there are places for 2 witnesses, although the statute doesn't specifically require it. We recommend that you do. And again, we recommend that you use the form as promulgated in the statute. This is, we're not going to cover this today.
Statute, right.
And again, the TODD revocation form, the statute contains questions directed at a layperson on how to use the TODD. There are still some underwriting questions that will come up, and at this point, we're ready to conclude our presentation. Our information is on the screen if you'd like to contact either of us feel free to do so. And Marcy, we're happy to take any questions at this time.
Perfect.
We hope that you found it informative.
Yes, it's wonderful. All right, so here's your first question. I am troubled that execution of this deed evidently requires what amounts to testamentary capacity. Who at the execution table would ever determine that? Does that not worry you as title professionals?
You know what? Every deed we take for recording, we're making the presumption that the person had the right capacity to do so. So as title people, it doesn't trouble us because it's in no way, shape, or form different than a deed we take every single day. You know, in most transactions that we do, both parties are represented by counsel. I would think that an attorney who represented someone who was incompetent and didn't point that out to anyone would have severe consequences. Yeah, I have been doing this, I hate to admit my age, folks, but for over 40 years. I have not encountered that problem yet, because between the notary and in the old days, you know, pre-COVID, the sellers were at the closing table. My closers are, you know, able to make an assessment. Are they psychiatrists or medical doctors? And any? No, but you know if somebody has capacity,
right,
or not. So the short answer is no. We're no more concerned than we are with the testamentary deed.
But the notary and the witnesses are going to have to make that determination, though, the same as they would any other transaction.
The next question is, go over the example again of the joint tenancy severed by divorce. How does it affect the TODD?
Okay. Under the statute, if Keith and I are married, we're tenants by the entirety, or we could take title as joint tenants with right of survivorship, which, you know, which means if one of us dies, the other gets the property.
Right.
This statute specifically provides that if the owners or the transferors of the property are either joint tenants or tenancy by the entirety, and they execute a TODD to Marcy, both of us must pass before any interest passes in the property. So the statute also says if Jean and Keith are tenants in common, meaning if I pass away, my interest passes through my estate. If Keith passes away, his interest passes through his estate. And let's say we have 50% each. If that is the case, and we together execute a TODD to Marcy, Marcy will get 50% interest upon my death, the remaining 50% interest upon Keith's death.
Right.
So I hope that clarifies the situation. I mean, the question.
Yes, and I'm so happy that I didn't get hit by a Greyhound bus in this example. Thank you.
We try using those examples.
No one's getting hit by a Greyhound bus today. The next one says, notice of claim served on fiduciary but not filed in the court in all counties.
Can you repeat that? You came in and out a little bit there.
So they said notice of claim served on fiduciary but not filed in the court in all counties.
I mean, to the extent it's not filed, we're not going to know about it. I mean, there's not a whole lot that we're going to be able to do in that instance. And recall that the recording statute is still operative. So even if somebody wanted to say, hey, you know, I have this document here that gives me an interest. Well, show me where it was recorded. Show me that you're complying with RPL 291 so as to provide constructive notice. And, you know, maybe then we have a conversation about whether or not that document, number one, creates a lien, and then number two, provides constructive notice of that lien. I'm not sure that the notice of claim against the estate is gonna do that necessarily, because I don't think it rises to the level of a lien. And then that's even more so where it's not, where it's not filed. I mean, if you look at, and I'll draw a comparison between, this statute and CPLR 5203. CPLR 5203 is the statute that governs the priority of judgments, liens of judgments against real property. A judgment only becomes a lien when it is docketed with the clerk's office. All right, so it doesn't.
Because remember, we're in New York is a race notice
Right.
jurisdiction.
Right,
So you must race to the courthouse to put the world on notice of your interests.
Right.
And whoever gets to the courthouse first, in most instances, will have the greater priority.
right. And I've definitely litigated cases in the past where, maybe there was a judgment even in another jurisdiction, and we've insured title. Maybe it was a judgment against a husband that was docketed in Pennsylvania. And, the husband and wife own property in the Bronx, and then they transfer the property into the wife's name, and we insure a mortgage, and then the creditor comes forward. I mean, it's, again, they didn't docket their judgment properly. They didn't record their lien so as to provide constructive notice. So I think that that's going to be the operative question. Is the document a lien? Does it evidence a lien? And does it provide constructive notice? And I think that if the answer to either of those questions is no, from an insurability standpoint, we're probably going to be okay moving forward.
Agreed. Any others, Marcy?
No, that's it. Thank you so much, Jean and Keith. I so appreciate this. This was so informative. Thank you, everyone who attended today for Notary Public Day. I hope you all are got something from this. Jean and Keith have their contact information up here. You can certainly reach out if you have any questions or concerns going forward. But thank you all so much for coming today.
Thanks for having us.
Thank you
Have
for
a great day.